Hi, everyone. So welcome to Northern Justice Watch's live project session 4. Thank you for joining us for this important conversation. Northern Justice Watch and its live project I think it's a unique education series, and it brings international law, human rights experts directly into dialogue with survivor communities. And I think it's a really valuable space for learning and for connection and for us deciding how to act together. It's equipping people with knowledge, with tools that we all need to pursue justice and accountability. So, and just if this is your first session with Northern Justice Watch, a couple sentences about them. Northern Justice Watch is a Canadian organization. It's dedicated to advancing justice for communities affected by atrocity crimes and political repression. And then through legal education, advocacy, and survivor support, Northern Justice Watch works to hold perpetrators accountable and to empower victims in Canada and around the world. And my name is Joanne Hodges. I'm a co-founder and serve as the facilitator of the Alliance of Genocide Victim Communities here in Canada. And in my work, I feel I have the privilege really to walk alongside survivors and communities who have endured various atrocity crimes. And I know firsthand how deeply the question of justice really matters to all of us survivors and those who care for them. Today, we are very fortunate to be joined by Amanda Garameni. She's an international criminal and human rights lawyer. She's dedicated her career to issues of accountability and justice. And Amanda is going to help explore how atrocity crimes are addressed within Canada's legal systems, which include the Crimes Against Humanity and the War Crimes Act, and what some of the opportunities and what challenges are that lie ahead. And she just spoke recently, just a few weeks ago in session 3, about international mechanisms. So I think this is going to be really helpful to cover some of these domestic mechanisms. So for the format, I just wanted to quickly say Amanda is going to first cover some ground in a lecture, and then we're going to take a break. And then in the second half, I'll be asking Amanda some questions, kind of like a podcast style. And we're going to throw the door open also for any questions that anyone has here in the audience. So feel free to drop all those questions in the chat and we'll keep an eye on them. And I would just say, as an opening, I would really invite you to listen and think about not only how these issues touch global justice, but also the lived realities of communities right here in Canada. And together, I hope we'll consider how law can move from being a reflection of our shared values that lives on paper to something in action that has impact and that truly validates survivors' experiences and advances accountability and helps put our values into practice. So with that, let me introduce our esteemed speaker, Amanda. She's a research fellow with the Human Rights Center. She's an international human rights lawyer, as I mentioned, and consultant. Amanda was previously the legal director of the Canadian Centre for International Justice, and her expertise includes international criminal law, international humanitarian law, corporate accountability, universal jurisdiction, and targeted human rights sanctions. Her recent work includes co-authoring the legal analysis on genocide for the National Inquiry into Missing and Murdered Indigenous Women and Girls in Canada, litigating against a Canadian mining company for corporate accountability in the Araya versus Nevsun case, and successfully leading the international campaign to release Iranian-Canadian political prisoner Professor Halma Putfar from arbitrary detention in Iran. So with that, I will send it over to you, Amanda, and I'll be.
Thank you so much, Joanne, for that introduction, and to Northern Justice Watch for inviting me to join you once again. I was really pleased to join the session last time where we discussed international accountability mechanisms, and this time we're going to shift our focus and look at domestic accountability in Canada. And so, as Joanne mentioned, I will start off with a brief presentation just to give a bit of an overview of what we mean by domestic accountability here in Canada. And then I'll be very happy to have a Q&A session with Joanne and to open it up to everybody who may have questions. And I would be very happy to answer any questions that you have, both here and later on if any questions come up later. So I'm going to share my screen. Hopefully I will be able to do this. Let's see. Can you see my PowerPoint? Wonderful. Okay. So we're going to be talking about domestic accountability mechanisms as opposed to international accountability mechanisms. And what do we actually mean by that? What we mean by domestic accountability mechanisms is that we're really focusing this time on processes in Canada that ensure or allow either states, entities, and individuals to be held responsible for violations of international law. And so what I'm going to do is I'm going to give an overview of 3 different types of accountability pathways that I think sum up the opportunities that we would have here in Canada. They each have pros and cons. They each have opportunities, but also certain barriers, and we'll discuss them both during the presentation and in the Q&A afterwards. But I'd like to start with one general category, which is criminal accountability. Now, Canada has the Criminal Code of Canada, and it also has a legislation called the Crimes Against Humanity and War Crimes Act, which gives Canada something called universal jurisdiction for very specific crimes, which are genocide, war crimes, and crimes against humanity. Now, what this means is that Canada can prosecute an individual for committing these acts or these crimes, even if they were committed outside of Canada and not inside Canada. It's also important to note that torture is also criminalized both as a crime against humanity, but also as a separate standalone crime under the Criminal Code. And the Crimes Against Humanity and War Crimes Act, it came into effect in Canada in 2000, in the year 2000. And normally in criminal law, this means that you can only then use this legislation and prosecute these crimes after that date. However, in this particular case, it's possible to prosecute crimes that took place earlier if the crimes existed under customary international law at the time and the place that they were committed. So this opens the door to many further situations of these types of crimes and of these types of human rights abuses. For torture as a standalone crime, it was only introduced into the Criminal Code in 1985. So for that crime, you can only prosecute it after that date and moving forward. Now, there's no limit within which you can bring legal action for these types of crimes. There's no limitation period. And cases can be brought against individuals and corporations, though corporate accountability, corporate criminal accountability hasn't really been tested in Canada, so it's hard to know exactly how that would be treated, but it is a possibility. And these cases can be brought either for direct involvement or for complicity in these crimes, which means that a prosecution can take place against a person who actually physically committed the crime, or their superiors or their commanders who may have ordered them to do it. Now, this is generally what we call universal jurisdiction, and there are some restrictions to universal jurisdiction, or there are some limitations to universal jurisdiction that are really important for us to discuss. First, generally speaking, the perpetrator must be on Canadian soil. So although there are some exceptions legally, in practice, it is very, very unlikely that an investigation or a case will be opened if there's no reasonable prospect of apprehending a suspect on Canadian soil. And in fact, the presence of a suspect is often the first criteria that Canadian authorities will assess when they're considering whether or not to even open an investigation under universal jurisdiction. The second thing that's really important to keep in mind here is that political approval is needed by the Attorney General to be able to start a prosecution under this regime. So that means that if there's a particularly sensitive political situation, one in which Canada doesn't necessarily want to involve itself or does not want to engage in, then the Attorney General can refuse consent, and that would prevent a prosecution from happening. So there is a political dimension to this pathway. And finally, prosecutors have really broad discretion under universal jurisdiction in Canada to decide whether or not they want to pursue a case. So they'll usually look at two criteria. One, they're going to look at the likelihood of a conviction. And two, they're going to look at whether the case is in the public interest. And so to date, based on this regime and based on these criteria, we've only seen two prosecutions under this regime, both of which were related to the Rwandan War. One ended in a conviction and the other one ended in an acquittal. And we haven't really seen a prosecution like this in the last 20 years. So that's the criminal pathway available in Canada for accountability for these types of crimes. The second umbrella, the second category that I'd like to discuss with you is what we call civil accountability. And this is separate from criminal accountability because it means that no one is going to be arrested or prosecuted or imprisoned, but rather that survivors and victims can seek compensation and civil remedies from their perpetrator, which is usually in the form of a financial settlement, which is the way that our system is set up. Now, civil lawsuits can be filed against individuals or entities such as corporations, but there is a very, very big barrier to this particular avenue when it comes to seeking redress or justice for state violence or state-sponsored harms. And when I say state violence, what I mean is that if the state was involved in, let's say, torture or in genocide or in certain crimes against communities or individuals, there is a legislation here in Canada known as the State Immunity Act, which essentially gives immunity to states and state agents from civil lawsuits in Canada. This means that you cannot bring a lawsuit in Canada against a state agent, against a high-ranking official that may have been involved in one of these types of crimes. There are some exceptions to the State Immunity Act, and there's a few exceptions that are listed in the statute, and they're limited to very specific circumstances. So one example is a commercial exception. If there's a commercial dealing, then a state can be, then there can be a lawsuit against the state under a commercial contract. But unfortunately, there is no exception currently that deals specifically with human rights abuses, such as torture or such as international crimes. So as the law currently stands, if you wanted to bring a civil lawsuit against a government official, you would not be allowed to do that because of this legislation. And unfortunately, this has prevented a large number of cases where survivors have attempted to seek accountability against states or state agents in Canada. Now, that being said, while states have immunity, corporations don't have immunity. And so there is still an opportunity under the civil regime, under civil accountability, there is still an opportunity to bring claims against corporations and against non-state individuals for their complicity in state violence or abuses that have been carried out by state actors. And I can talk about this a little bit later, but there was a case that I worked on that went to the Supreme Court. And what the Supreme Court said in that case was that, first of all, corporations can be sued in Canadian courts under international law. So if a corporation violates customary international law, such as crimes against humanity, then the corporation is not immune from a civil lawsuit, unlike a state. And the second thing that they said was that a breach of customary international law should then offer an appropriate remedy under Canadian law. So if a breach occurs, then victims should be able to bring a lawsuit in Canada, in Canadian courts, to try to obtain justice and redress. So this is civil accountability. There are certainly some barriers under this umbrella, under this category, but it is a category that exists for domestic accountability. Now, finally, there's also a third category that I'd like us to discuss, and this is what I would call political accountability. And I guess what I call political accountability is not necessarily a legal procedure. It's not necessarily a lawsuit or a criminal justice procedure with legal ramifications. However, it's a political procedure that really is contingent on the government of Canada and the discretion of people in political authority. And so a really good example of political accountability would be something like the imposition of sanctions on countries or on individuals for certain conduct. So this isn't necessarily accountability in its truest form because it's not a legal process that's related to necessarily truth finding or victim compensation or victim redress, but it's an opportunity for a state like Canada to try to elicit behavioral change from other political actors to try to get them to stop engaging in certain conduct. And so the way that I like to think of this tool is really like a carrot and a stick, a tool to encourage states to act in a certain way in accordance with certain principles. And the tool is meant to be adaptable, so it's not permanent. It's not about punishment, but it's about how do we encourage states to behave in ways that are aligned with our values. And so in Canada, there are a few different sanctions regimes that I think are quite relevant to the discussion that we're having today. One of them is the implementation of the UN Security Council sanctions. So these sanctions are often related to peace and security, and if the UN Security Council imposes certain sanctions on countries in relation to the breach of international peace and security, Canada has an obligation by law to also implement those sanctions domestically. And so there are a number of sanctions that are currently in force that are related to UN and UN sanctions. But there's also another category of sanctions. Well, there are a couple other categories, but there's a main one that's quite relevant here, which is related to human rights. And this is a sanction that actually targets individuals or entities for their complicity in gross human rights abuses or in corruption, but abuses such as extrajudicial killings, torture, sexual violence, enforced disappearances, things of this nature or of the same scale and gravity of this nature. And this is what we call targeted human rights sanctions. So the Canadian government has used these types of sanctions against state actors involved in a variety of different abuses. I can give some examples, and then I can certainly talk about this a little bit more later on in the Q&A. But for example, we have seen already now in Canada sanctions against Saudi officials who were involved in Jamal Khashoggi's killing. We have seen sanctions against officials in Myanmar for abuses against the Rohingya. We've seen Chechen officials that have been sanctioned for abuses against the LGBTQ community, and also Iranian officials from a variety of different contexts for very specific human rights abuses or corruption. So this is what I would call political accountability. And I'm happy to discuss this further later on as we discuss these in greater detail. So I'll probably end this initial presentation now. This really gives you an overview of the three different categories of domestic accountability mechanisms that we have in Canada. But if you have any other questions, I'm sure Joanne will ask some interesting questions. And also, if you have any other questions that we didn't address in the Q&A, I'll be very happy to answer them.
Thanks for that, Amanda. You have a way of making these avenues very clear and understandable. So thank you for that summary. And I think it's a great launching point for us for conversation. And don't forget to drop your questions in the chat room. We had scheduled a 10-minute break. We're a couple of minutes early, but I think we should still probably take just that break. So please stretch, grab a coffee or a snack. We're going to be back here right at 12:30. We've got a bunch of questions to get through and chat just that we already have scheduled. So, but please do feel free to ask more. But we'll take a break. Be back in 10 minutes. I hope you had a chance to recharge and maybe stretch your legs for a few minutes. And we're going to shift now into this second portion. It's a podcast style part of today's seminar. And it's just more conversational in general. And I get to ask Amanda a bunch of questions. Think of this as like pulling back the curtain. We're going to ask questions that I think survivors and advocates carry every day. And Amanda's going to help us unpack what Canadian law can actually do and where the gaps are and what possibilities even exist for justice and for accountability here. So thanks, Amanda. Again, for providing the first half and the last session. And then I think this overview of these three different types of pathways that are available in Canada for accountability for human rights abuses that have been committed abroad. I thought we could take a bit more, well, we could talk about each of the pathways, and we can start with criminal accountability. You mentioned that just two cases have been prosecuted in Canada in the last 25 years. Why would you say there have been so few cases in Canada?
Thanks, Joanne. And one thing I just wanted to mention is that, I know that these seminars are really meant to provide accessible information to communities, survivors, individuals that want to better understand what accountability pathways there might be that might offer them for their specific situations. So to the extent that I can, speak about all of these things in more accessible language, that's what I'm going to attempt to do today. So I won't get super technical. But if there are questions, more technical questions, I'm also very happy to answer those. And if anyone wants to put them in the chat as we have our conversation. But I'm really trying to give more of a big picture understanding of what accountability means in Canada and what these opportunities are. And so I will dive into that. The other small caveat that I also wanted to make is I do know that some communities might have very specific questions because they have been looking into these, into specific cases, into specific opportunities. And the only thing that I'll say is that in your questions, I think to the extent possible, I'll try to keep everything quite general in a public session like today. If there are very specific questions about specific individuals or specific cases, feel free to save those questions and follow up separately with Northern Justice Watch. They'll send those questions to me, and I'll be more than happy to set up a more private conversation to discuss, specific issues. But because this is an open session and this is going to be live streamed and it's going to be online, I'll try to keep it as general but specific as possible. So I just wanted to start off with those two caveats. But you've asked a really important question, and it's a question that as a lawyer, I've asked over the last 25 years. I've had clients that have asked this. I've had colleagues that have asked this. It's a really big question, because what is the point of having this type of legislation and this type of opportunity if it's not actually going to be utilized and if we're not actually going to be seeing cases? I think there are a few really important reasons why we've only seen 2 cases. First, it's important to highlight just how complex and time-consuming and resource-intensive cross-border investigations are, especially of this nature. And to have a successful prosecution, the prosecutor really must prove a case beyond a reasonable doubt. So when we're in the criminal justice realm, there's a really high standard and a really high bar that has to be met, more so than just a human rights investigation to put out a report or even a media investigation to put out news coverage. It's a very different type of process to investigate these types of cases, and it's a really high bar. And so I think that's part of the reason we haven't seen that many prosecutions, is because to carry out a thorough and effective and successful investigation, it is really complex and really difficult. And it requires a lot of resources, including financial resources, but also technical expertise, language expertise. So while there are a number of investigations that are underway right now and that have been underway over the last 25 years within the war crimes program, what it seems like is that none of them have actually reached a point where prosecutors believe that they could successfully prosecute a case. And so I think that's one of the biggest reasons why we haven't seen this type of prosecution, for the last 20 years. The second thing is that the program hasn't received an increase in their budget essentially since they started. So for more than 25 years now, they have been working with a very limited budget. So as I mentioned, the resource-intensive nature of these types of investigations, the fact that they're investigating crimes that happened in other countries, and there are a lot of barriers to having physical access to those environments, forensic access to those environments, to being able to conduct interviews with witnesses, having interpreters, having cultural experts. There's a lot that goes into carrying out an appropriate and adequate and effective investigation. And it requires financial resources. And the War Crimes Program has not received an increase to their budget in the last 25 years, which means that it has also been a big barrier to having these types of prosecutions. And then finally, there needs to be political will to spend the time that's necessary and to spend resources that are necessary on prosecutions. And what we've seen is that Canada's current policy has placed much more of an emphasis on immigration remedies rather than on investigating and prosecuting cases. So the motto of Canada's policy is no safe haven. That's the name that they've given to it. Canada will not be a safe haven to war criminals. And what they've done with this motto is that they've really focused on not allowing war criminals, alleged war criminals, into the country or letting them live here or stay here. So instead of actually seeing the presence of potential perpetrators or alleged perpetrators in Canada as an opportunity to investigate and prosecute, what Canada has done is that it has focused on inadmissibility of people into Canada, not letting them in to begin with, or on cases of deportation out of the country, so getting them out of Canada. And that is part of the policy that we've seen with the War Crimes Program over the last 25 years. And my question, I'm curious, is that given what we've seen about not really having any prosecutions over the last 25 years, is this policy working? Is this actually an effective way to seek justice and accountability? And I wonder if the people within the War Crimes Program are evaluating this and thinking about this. They used to publish a report every few years about the impact of the program, about the successes, the strengths, the weaknesses. We haven't seen a thorough report from the War Crimes Program itself, I think since 2015, if I'm correct. And so I think we are overdue for an assessment, an impact assessment of whether this policy and whether the way Canada has engaged in universal jurisdiction has actually been effective. And I'm hoping that maybe we'll get some answers soon.
That's really, that's helpful. Yeah. And I know, like, when we have this, we know that perpetrators have still been able to come here. And so we need to perhaps to have this reawakening also to the need to have perpetrators actually held accountable when they have managed to come here and sneak through those immigration and not be kept out of the way that they're intending to. And that increase in the budget is a real need and something that is long overdue. And then when it comes to the financial and practical barriers for these cases in Canada, how important would you say the role is of civil society organizations? For example, like the Alliance of Genocide Victim Communities, the one I lead, or when it comes to moving atrocity accountability cases forward in Canada, what are some of the things that you would say survivor communities could do to support criminal prosecutions?
Yeah, look, civil society organizations play a very important role. And I think that there is an opportunity for civil society organizations to engage with Canada on both the political front in terms of building the political will that's needed to engage in this type of accountability, but also on the investigative front, which is providing information that can potentially be evidence. I think these are the two kind of main categories that I see civil society organizations being able to support the War Crimes Program and the objectives of the War Crimes Program. So as I mentioned earlier, right, we need political will, we need the government, and we need the political branch, we need the Department of Justice, we need all of the members of the War Crimes Program to have the will to engage in this type of accountability. And so if the government knows that there's a large diaspora community of survivors in Canada who want accountability, I think that this can have a really big influence. And I think one very concrete example that we've seen is when with Ukraine. I mean, look at Ukraine. We have a huge diaspora of Ukrainians in Canada. And when Russia reinvaded Ukraine in 2022, we saw mass mobilization of a diaspora community that pushed the government, that raised their voice, that was able to build allyship within members of government, with members of parliament, and they really pushed their agenda and their objectives. And we saw a very swift reaction from Canada, right? So spending time raising awareness about what's going on in a given context, speaking with your members of parliament. If you have a diaspora across Canada, you can engage with different members of parliament, different ridings, lobbying the government to prioritize accountability for these types of abuses in a specific situation or in a specific context. All of this can be very helpful. So I think that's the political will side of it. And then I also mentioned that these types of investigations can be very difficult because there are language barriers, there's a lack of full cultural contextual understanding of what's happening in a given situation. There needs to be evidence collection across borders in sometimes very inaccessible spaces. And so this is where survivors and impacted communities can also contribute to the investigative side of things. So, diaspora communities are often going to be the first people to know, for example, whether there's a perpetrator in Canada. Or as a survivor, there might be really valuable information about what happened, when it happened, where it happened, who did it. And so these are the types of details that are crucial to an investigation. And with the help of lawyers in Canada that are specialized in these types of cases, it's important for survivors to share that information and evidence with the War Crimes Program and to also push them, to formally ask them to open an investigation. And this is the type of work that I was doing with the Canadian Centre for International Justice, and it's the type of work that I do as a lawyer here, because it is difficult for communities, for civil society groups that don't have this expertise to just engage directly with the War Crimes Program. There are ways in which their evidence can be preserved, the information that they have can be evaluated as to whether it's relevant or not relevant. And so it's really helpful to work with lawyers that are specialized in this to essentially put together a package that can be given to the War Crimes Program and to also push the War Crimes Program itself into carrying out their own investigation, right? Because no matter what civil society groups do, no matter what information they collect, the investigators, the RCMP, the members of this War Crimes Program, they will have to carry out their own impartial and independent investigation. But what civil society communities can do is that they can give them information, they can give them leads into where they should look, who they should talk to, what they should do, and encourage them to go ahead and follow through with an investigation and potentially opening up a case. So this is how I see civil society getting involved.
Yeah, that's helpful. I think, it could be helpful to know or to circulate within some survivor communities, like it's a kind of checklist, essentially, of what you do when you have evidence. The sense that there was some also kind of centralized place that, where they knew they could go to understand what steps and what kind of a guide there could be, in order to share their information the best way possible, essentially. And speaking of evidence, something I think I've heard from survivors is how much evidence, how many personal stories they have. And so could talk a bit about what kinds of evidence Canadian courts require to pursue atrocity crimes, how diaspora communities, I'm thinking of the Tamil survivors, the Tigrayan families that I've talked to, and others, how can they contribute testimony, documentation, other forms of evidence that can really support a legal process?
Yeah, that's a really good question. And again, without getting too technical, perhaps I can explain, first of all, just what form evidence can take, right? Evidence can take different forms. So you've highlighted a few in your question. There's documentary evidence. So this is like documents, photos, papers, identity documents, fingerprints, things that are, documents that can provide information about a variety of different elements of a crime. But there's also testimonial evidence, right? So survivor statements, witness statements, providing information about what was seen, what was heard, what type of actual testimonial information someone might have. And then there's also digital evidence, right? There's videos, there's recordings, voice recordings. It can include social media posts, metadata from photos and videos online. It can include satellite imagery, GPS coordinates. There's a number of different types of digital evidence that also can fall in this category. And we also have expert evidence, right? We have experts that can offer information about historical or political context or cultural context. There can be insiders, people that understand the internal workings of a certain government department or the military or the groups that are perpetrator groups. We can get medical expertise. So all of these are different types of evidence. Now, the evidence also needs to speak to different elements of the crime that need to be proven in an investigation and in a prosecution. So, for example, evidence that a crime took place in a specific place, in a specific location, time, any type of information that can prove this element is going to be useful, right? There's also the need to get evidence that identifies the perpetrator and the victim. Who is the perpetrator? What are details that we know about the perpetrator group, and what about the victim? Who was the victim? This is also important information that helps build a specific case. There's also something that we call linkage evidence, which is information that links the specific crime, the specific conduct, to the specific perpetrator that actually carried out that conduct. And that type of linkage evidence is crucial in cases like this. And for universal jurisdiction cases, something that I think is undervalued sometimes is that it's really important to have information about the presence of a perpetrator in Canada, because that is going to be one of the main criterias for the war crimes program to decide whether they're going to prioritize a case or whether they're going to open an investigation. And so having information from the diaspora community about a specific person who may be linked to a specific crime and the fact that they are living or they are present in Canada can also be really important. So all of these are important details that serve the investigation, and that civil society organizations might have access to this type of information and can provide it to help.
So along those lines about, different types of evidence, there seems to be this increasing trend of atrocity crimes that are documented on phones, on social media, and satellite imagery. For example, if I think about the atrocities in Xinjiang, it's all digital, satellite images, leaked documents, etc. In Tigray, so many of the crimes were recorded and spread all over social media. Would those types of evidence actually be accepted in Canada's courts today?
Yes. Yes, it's a very, very good question. It's also a very timely question because this is something that lawyers, investigators have been thinking about and working on for the last few years, especially as more and more, let's say, crime scenes are inaccessible. So it's hard to actually go physically to certain locations and to access information. So there's been a kind of a surge of what we call open source intelligence gathering. And this is, really using online methods and means of investigating where you can't go into China, or you can't go into North Korea, or you can't go into Iran or Syria or other places. What type of information is coming out of those places that's being posted online that people can then use and potentially submit as evidence, and whether that's actually going to be admissible in court. So this is a very important topic. In short, this information can be accepted. However, I think it's really important that that people understand that this information needs to be authenticated, right? So investigators need to authenticate the digital evidence and prove the provenance of the information. Where did this information come from? What is the original source of the information? And corroborate the veracity of the information. So for these types of materials to ultimately be admissible in court, there are a variety of steps that need to be taken by the investigators, by the lawyers that would like to submit this and use this to make sure that the information was preserved properly, that the metadata, that technical aspects that can tell us where the digital information was taken, when, where, by whom. A lot of this needs to be preserved, and then to also corroborate that this is real, that this is credible. And so, when digital evidence has been passed around and has gone through multiple hands, either through WhatsApp groups or Telegram channels, or if it's posted on social media and it's been shared, it can be a lot harder to trace it back to the original poster, or to trace it back to the person who took the video or took the photo, or identified the location. And one of the things that we are grappling with today that is especially problematic is if the digital information or the digital document has been edited or manipulated in any way, which now with technology, it's more and more plausible to do that. So it can be really, really difficult to find the unadulterated version of that digital document. So in those types of cases, it actually might not ultimately be admissible in court, which is why I always tell people, it's really important, especially civil society groups and communities that are very online and very savvy and do have a lot of materials coming through online, that it's really important to understand the basics of collecting and preserving digital evidence to make sure that they can increase the likelihood that it can actually be used. Now, that being said, I do think it's also really important to note that even if digital information itself is ultimately not admissible in court, it doesn't necessarily mean that it's not valuable. This type of information can be incredibly helpful as lead information. It can be used as part of an investigation to help better identify where to look and who to speak to, and to help investigators get a better sense of the crimes and what happened, in order to then go and obtain the type of evidence that will ultimately be admissible in court. So even, if the digital evidence itself isn't used, it's still really important to know that it's useful.
That's helpful. That actually kind of followed. That was one of my follow-up questions about that, essentially. And with so I think that when you have this problem with authentication, where it came from, the metadata, and it's scrubbed. Like, for example, in the Tigray community, we're seeing that a lot of the evidence is disappearing from online. Actually, there's like a scrubbing of all atrocities that were committed from online. And the need for to understand basics of collecting and preserving digital evidence. I know there are some in the community that have that knowledge, but I think it could also be very helpful, again, hey, Northern Justice Watch, perhaps, to have some educational session around something like that for many of our communities who are increasingly seeing this, and when it's happening live, that to make sure that you're really collecting it in an appropriate way. I wanted to circle back for a second. I have a question about how cases get picked up. And, we talked about large diaspora communities wanting accountability, and that can be helpful when there's that. So you need the political will. So like the Tamil community, for example, is very large in Canada. It's the largest outside of Sri Lanka is here in Canada. Not as big as the Ukrainian community, but it's big for the Tamil community, essentially. We've seen the Canadian government be outspoken about atrocities that were committed in Ukraine and in Syria. But Tigrayans, Hazara, Rohingya, Yazidi, we've all experienced these repeated atrocities and massacres as well. And yet accountability is almost non-existent for all of them. Why do some atrocity cases gain traction in Canada while others seem?
Thanks for the question, Joanne. It's a really important question. It speaks to political will. And I don't know that I have a great answer, because at the end of the day, these things are ultimately political, and although I wish that we lived in a world and in a country, in Canada, where there was a principled and a consistent approach to all conflicts, we have seen time and again that that's not the case. We see it on the international scene, and we also see it play out here in Canada in our domestic politics and in our domestic policies. And like one ongoing example that we can look at right now is the Canadian government's approach to Gaza and Palestine, right? This is a really great example of how there isn't a consistent approach and a consistent policy. Justice is only, I think justice in the Canadian context is only applicable to some and not others. And that's not fair. And that's not, that's not the type of country that I would like to be operating in and living in. So I do think it's a really big question, and it's something that we all need to reflect on and think about. How do we make this a more fair, just, and equitable system? And, I'll give you another very concrete example. So, in 2021, when the US and Canada withdrew from Afghanistan, I worked for many, many months to get at-risk Afghans out of Afghanistan after they left, after the US and Canada left, as including, individuals who had helped the Canadian government, individuals who were involved in supporting the Canadians in different civil society capacity building development projects and programs and justice programs. And I spoke with the highest levels of the Canadian government. I spoke on the phone with the Minister of Justice at the time, explaining the situation, the people that were at risk, and why they needed to be supported. And I was told that nothing could be done, that unfortunately there's a process, there's a system, there's a queue, we can't do anything, there's nothing that can be done, right? And then when the war in Ukraine started in 2022, all of a sudden, Canada had a special visa pathway for Ukrainian refugees that they were to set up, I want to say, in a matter of weeks. In a matter of weeks, they had a special pathway specifically for Ukrainian refugees. Now, I'm very glad that they made this possible for Ukrainians, because it's not about devaluing the suffering of one community over another. It is really important that this was made available to Ukrainians and that they were able to come and seek safety. But I was so incredibly upset because they didn't do the same thing for Afghan people. They certainly didn't do the same thing for Eritreans or Tigrayans, for Yemeni, for so many other victim groups who had been suffering similarly and for a very long time. And so my question is, like, why exceptionalize only one group? Why not make a pathway for all people that are facing similar circumstances with clear criteria that if those criteria are met, then the people are eligible, right? Why do this ad hoc, we're going to do it for one community and not the other, right? This is exceptionalization. And so all I can really say is that if we want the government to care, whether it's about refugee issues and communities that are fleeing conflict, or whether it's about seeking justice and accountability in Canada, I think communities need to make as much noise as possible. I think they need to really bring up the topic as much as possible, and make sure that the government sees them as constituents, sees them as part of the people that they need to deliver to, that they are accountable to, and if they want to be elected, then they need to care about these issues. And I think that's where we can push back and try to encourage the government, and sometimes even force the government to be more consistent and to have a principled approach and to care about a lot of the different communities that are not the ones that are making the headlines, that are not the ones that are easy for Canada to support. It shouldn't be about what's easy and what's politically expedient or what's gonna make them feel better. It should be about just, equitable, and fair solutions for all people and making sure everyone feels cared for.
Hear, hear. And I feel like,
Yeah. Sorry, I'm commiserating with you and with so many communities. I don't think I gave an answer to that question.
I feel the solidarity. That's exactly what we need. I feel like, in Canada, it feels like we have an opportunity to lead on this in the world, possibly because we have the world living here. So we have communities that have been impacted by all of these atrocity crimes. And so if we can show, or we can be an example of how we can be principled, or how perhaps we can actually reflect our values. Do we actually have values as a country? How do we creatively articulate and defend those values in order and uphold them? Perhaps we can be a model for the world because we have that unique composition here in Canada. So it's a big effort ahead. Okay, so shifting gears a little bit, there are also these patterns of different atrocity crimes being committed. Sometimes they're in combination, and I'm thinking of these double situations where you've got, for example, like many Hazara and Tigrayan women and girls who face both ethnic cleansing and gender-based persecution. And I'm wondering about how Canadian law allows for those intersectional recognition of crimes. Does it at that space?
Yeah, that's a very important question. And thinking about intersectionality in this space has been something really important for me over the last few years in terms of thinking about how do we make sure that we have a full, a thorough, a holistic understanding of a conflict and that people are not falling through the cracks, that they're not under the radar, that we're fully understanding how intersecting identities can impact people and how these crimes are committed because of these different identities and how they interact with each other. So I think this is a really important question. Intersectionality as a concept, right? It's a crucial element to effective justice. And I think what's important to think about when it comes to intersectionality, that it's not just about intersectionality in the kind of in the prosecution or in the way that the laws are written, but it's about a process, right? It's about how to use it as an approach and how to incorporate it into the way that we do the work and the way that we understand these crimes, the way that we investigate the crimes. There's so many different facets and a life cycle to these types of cases, and intersectionality is a cross-cutting theme across all of them. So Canadian law incorporates international crimes as they are conceived in customary international law and under the Rome Statute, because Canada is a party to the Rome Statute. So yes, intersectionality, right? The law is broad enough that intersectional recognition is possible. But as I said, I think the issue starts even earlier when we're thinking of the pre-investigation, the planning, the investigation phases. So I think that intersectionality needs to be a method and an approach by which conflicts are actually analyzed and cases are investigated so that we can appropriately understand how violence impacts victims in different ways because of these different identities, and include these intersecting identities into how we understand vulnerable communities, harms, like how people are targeted, and how they live these conflicts. And so there is an ability, and this really comes down to the investigators, this comes down to the people that are building cases, this comes down to both civil society lawyers like myself who are doing some of the legwork and building and trying to build a theory of a case and submitting them to the war crimes unit, but it also needs to happen within the war crimes unit with the investigators, with the lawyers that are building the cases, with the prosecutors that are eventually going to prosecute. But there needs to be the incorporation of an intersectional approach from the outset, so that investigators can identify, the breadth of victims, the different types of crimes and abuses, the relevant perpetrators, so that there can be really a much broader understanding and a more effective and thorough investigation. Otherwise, if that doesn't happen, many people can be excluded from the cases and their harms can go under the radar, and they won't actually even be included as a victim group when it comes to the ultimate prosecution of these types of cases. So intersectionality is very important. It is very possible in Canadian law, but it really takes a careful and nuanced approach, and it takes lawyers, investigators, a large segment of people that are involved in these types of cases to get the adequate training, the adequate understanding of what intersectionality actually means and how to incorporate it as a method into what they do.
That's really interesting. And I wonder about how do you, and I don't mean to put you on the spot because you may not know this at all, but with the case that Canada's bringing with women in Afghanistan, I think about the Hazara women who are also, unfortunately, from the community. What they endure is actually often denied because it is because the strong collective of power that's committing the genocide is empowered in Afghanistan, and there can be a continued there can be this double victimization, right, that exists. And I wonder about whether their particular case, especially Hazara women, would be thinking of this as something that needs to be brought from the beginning at the outset in order for it to be recognized. Do you happen to know anything about that case in particular, and whether there is any movement towards recognizing the particular plight of Hazara women, for example, in Afghanistan?
Yeah, no, it's a really good question, and I've done a lot of work with the Afghan community here in Canada, and I've heard this many times that there really needs to be an understanding of the intersectionality of Hazara women who are targeted based on gender, but also based on their ethnicity, and so this is something that is a very live issue, and it's a very important issue. I don't have that much familiarity from the inside of the Canadian case in terms of what their strategies and what their theories are and what they're going to do. What I can say is that, from my understanding, they're going to be bringing a case under CEDAW, which is the Convention on the Elimination of Discrimination Against Women. And so to bring a case at the International Court of Justice, you have to bring it against parties that are both that have both signed a specific treaty that gives the court authority to take the case and to hear the case. And so you have to allege, a conflict or I guess a grievance on the interpretation of provisions within that treaty. So in that treaty, there are certainly provisions around how to protect women against violence and gender-based persecution. And so that certainly is going to be the central focal point of this case. And if that treaty also does acknowledge that there can be ethnic-based or other types of intersecting identities where women can be particularly vulnerable, then certainly it should be something that the Canadian government incorporates into their case. And even if that's not possible under the actual provisions of the treaty, I think there are ways of bringing in this information as contextual information, as information that helps explain how and why certain people in certain communities are being targeted. And so there are opportunities for this to be highlighted within the framework of that case. So I'm not working on that case, but I agree with you, and I certainly hope that the people who are working on that case are really going to think about intersectionality and think about having consultations and conversations with different members of the Afghan community, which is also not a homogenous community. There are many different types of people with different types of identities that have all suffered at the hands of the Taliban, and so it'll be really important for all of those views to be incorporated somehow.
Yeah, that's really helpful. One more intersecting question. So in my work with the AGBC, I often hear that many survivors encounter Canada first through our refugee system. And I'm wondering how refugee and immigration law intersects with atrocity crime accountability here.
Yeah. So it certainly does intersect. And I think there are a couple points. So the first is what you just mentioned, right? So many victims and survivors who have been harmed in another country often come to Canada because they left either a conflict zone or an environment where they were where their human rights were being abused, or some form of violence, and they found safety in Canada. So this is one point where refugee law and immigration law will intersect with atrocity crime accountability, because the victims, the survivors, the witnesses, these are people who are coming to Canada through these pathways. And so many of these survivors and witnesses who are now in Canada, they are able to provide evidence, they're able to provide testimony, they're able to serve as, and I don't like to use this terminology because it's very extractive, right? Survivors and witnesses and impacted communities are not just fountains of information, right? They are human beings that have been harmed, and there should be a victim-centered approach to how they are, how they engage in the criminal justice process. They're not just a tool for prosecutors or investigators to extract information from. There should be a much more, I think, human process in acknowledging their harms and acknowledging the trauma, and in incorporating their experiences into how these criminal cases are investigated and pursued. But they hold really valuable information, right? So this is one way in which there's an intersection here. But I think the other way, and this is something that I brought up earlier, is that immigration law is used by the War Crimes Program as a tool as well, particularly when prosecutions are not possible or not feasible or not desirable, but it's used essentially to avoid prosecuting and to actually use immigration remedies to either not admit people into Canada or to expel them from Canada or deport them from Canada. So as I mentioned, right, the War Crimes Program has immigration remedies such as inadmissibility and deportation and visa revocations or even like PR revocations that they can use as a way of not providing a safe haven to alleged war criminals without necessarily doing a full investigation and a full prosecution. And something that's really important to remember here is that, I mentioned that in a criminal prosecution, the standard for evidence, the standard to be proven is very, very high, right? Beyond a reasonable doubt. However, in immigration remedies, in using the immigration tools that are available, that standard is much lower, which means you don't need as much evidence, you don't need as much information, you don't need to prove it in the exact same way. And it makes it a lot easier. And at times, it also makes it quite problematic because there isn't the same level of due process built within those procedures that there would be in a criminal prosecution, which is quite important.
Interesting. Okay. So one more question along this, the criminal accountability. There are other countries around the world who are using universal jurisdiction to prosecute for atrocity crimes and seem to be doing it frequently. You're thinking of Germany and Sweden and other places. And I understand that Australia has a similar system to us for prosecuting. Is there anything that they have been doing that we could learn from, or from these other countries that we could be potentially learning from?
Yeah, I think that, the universal jurisdiction units in any given country, I think there's always room to learn from what other countries are doing, other colleagues are doing. It's important to exchange experiences, exchange information, to be able to constantly learn. As lawyers as well, we have continuing legal education because we need to keep learning about new methods and new laws and new ways that these things interact. So I think there's always room to learn and to learn across borders. But I also think when it comes to universal jurisdiction, it's really, really important to keep in mind that each country has its own laws and its own procedures and its own criminal justice system that makes it quite hard to do a one-to-one comparison across jurisdictions because a lot of factors will be very different. You brought up Germany, you brought up Australia. So, there are civil law systems and there are common law systems. Here in Canada, we have a common law system. A lot of the universal jurisdiction countries that have been the most prolific when it comes to these types of cases have actually been civil law systems because the civil law system, unlike our system, has different ways and key differences in terms of what they can and what they can't do, what type of evidence that they can admit and that they can't admit, how they can incorporate victims into the process, testimony into the process. There are a lot of different criteria, and each system has its own idiosyncrasies. So I think it's important to remember that you can't just look at a one-to-one comparison and say, well, how come Germany is doing all these cases and Canada isn't? There's certainly some room to critique, and I've been critiquing the Canadian government a lot in the course of this session, but I do also want to be fair that there are going to be different opportunities and different barriers. So in Canada, victims don't have a formal role in criminal prosecutions, but in many civil jurisdictions, such as in France or in Switzerland, victims can actually participate in a prosecution, and they can even instigate or initiate a prosecution. So they have a lot more power to force the hand of prosecutors to actually bring a case because they are a party, they can be a party to the case, whereas we don't have that here in Canada. Another important factor is the presence requirement. So some countries don't even require that that a perpetrator or an alleged perpetrator must be present on their territory to be able to start an investigation or to even pursue a prosecution. Whereas here in Canada, we need that presence, right? So that's gonna be a limiting factor in what types of cases we can bring here. Some countries, such as Germany, they have a much more porous border. They have a much larger flow of people that come through its land borders. And so there are often both more victims and individuals with information about these types of crimes and people that have been victimized. And on the flip side, there may also be more perpetrators that are on their territory that they could pursue, that they could investigate. And it makes investigating and gathering evidence a lot more feasible in that type of context. Whereas here in Canada, because of our geography and because of our refugee and immigration system, we don't necessarily have the same flow of people, right? Or, as I mentioned earlier, we are not admitting certain types of people into the country, and we have the ability to limit that flow because of just our geography and the fact that we only really have one land border. And so it makes these types of cases a lot more difficult, and the investigation and the prosecution of these cases a lot more difficult. So that being said, there are still some ways that I think Canada can learn from other jurisdictions, especially, for example, if we look at Europe, the way that European countries have collaborated across multiple different countries to engage in structural investigations when it comes to specific conflicts. They've done this with Syria, they're doing this with Ukraine. I think that's a really big lesson that Canada can learn. And I think it's a lesson that Canada has actually taken note and incorporated here as well into the way that they do things. Because as we've heard from the Canadian authorities, they have started doing more structural investigations. And when I say a structural investigation, what this means is that you don't necessarily have a specific perpetrator in mind, but you're still collecting a lot of contextual elements, a lot of information about the conflict, and building a theory of a case so that if and when a suspect or an alleged perpetrator is identified, you can plug them into an existing understanding of the conflict and the types of crimes that are being committed within that conflict. And Canada is doing that more and more. We've seen them do it with Ukraine. They've been doing it with Syria. They may be doing it with other contexts. So I do think Canada is engaging and is learning from their counterparts in other countries.
Really interesting. I have one follow-up question about that, which is, so something that we've been thinking about in some of the communities that are both being helped by Northern Justice Watch and AGBC, are thinking about, the possibility of creating an office of genocide prevention, essentially, in Canada. The idea being essentially that there would be some public facing reports that would be doing some of the structural investigation, essentially, as situations are developing around the world. We know that Global Affairs is very well informed about situations that are happening around the world, but so much of the actual information that reaches the politicians comes from diaspora communities, and diaspora communities actually doing the work or civil society organizations that are saying, look, there's these atrocity crimes happening here and there, and here are all the facts and data, and here's what we would like you to do, essentially. And so instead of having to do all of that legwork, which it's a huge burden on refugees who've just arrived here, essentially, we're saying, couldn't there be some kind of public reporting office that would already be saying, look, these situations look like there massive, crimes are being committed, essentially, of these different natures. Thoughts about something like that, off the cuff, sort of like, do you have any, immediate response to that type of idea, or whether you think it would be beneficial, or there's other ways to potentially, like, do institutions already exist, do you think, and have enough capacity? And what are your thoughts, just, I guess, reflecting on that idea?
Yeah. So I think one thing to remember, right, is that we are living in an age where we have a lot of information. And I think the issue isn't so much that we don't have the information, it's that we are so inundated and oversaturated with a lot of information, including conflicting information or misinformation, that it's hard to really like cut through that noise and actually understand what's going on. And I think that there are some longstanding institutions, human rights institutions like Human Rights Watch, like Amnesty International, like these supranational or like international organizations that are really monitoring what's going on in a lot of different contexts. And then there are also national human rights organizations within different countries that are already engaging at this high level of identifying human rights abuses, identifying things that are going on, patterns of conduct, government violence, state violence. You know, there's a lot of documentation that's already happening. So I think at that level, there is actually quite a lot of information that is available. What's difficult when it comes to like specific criminal justice cases is, like I said earlier, it's not sufficient to just have a human rights report saying that genocide is happening here or crimes against humanity are happening here. Because when we're looking at individual criminal accountability, individual criminal responsibility, we need to say that this specific person was involved in this specific crime in this specific way, and that we can link them to a very specific incident. So just saying that there's a genocide is not actually going to help us identify the very specific incident-based situation that would then make it possible to seek accountability against a person. There's a much more granular level of investigating that needs to happen because, again, we're talking about depriving someone of physical liberty, right? When we talk about criminal justice and about prosecuting someone, we need to be able to show beyond a reasonable doubt that this person was the person who committed this crime. And so that has also very serious due process implications and human rights implications on the rights of an accused. So it's a very precise process.
Yeah.
And so that's where I don't know necessarily if what you're suggesting would be the most useful, because I certainly think that bringing attention to the government, bringing this information that's already being collected, that's already being monitored is useful. But it's not to say that diaspora communities or refugee communities or even survivor communities need to be doing that legal analysis to say, hey, this is what's happening. This is, what's going on. It is happening. There are a lot of different organizations, a lot of lawyers that are doing this work. I think where diaspora communities can be incredibly helpful is that they will often be the frontline individuals who will have lived, who will have had that precise type of information, that granular information, to help investigators plug in a specific incident within a larger context that they already have, and that they already, are able to collect information from different sources. That's where I think we have to really focus our attention on. That would be my suggestion.
Yeah, that makes a lot of sense because, I think that the idea of that type of office is more perhaps about political will and not about actually accountability and prosecuting. It's more about like general knowledge. And then also, so that I think, that's helpful to clarify. Thinking about, we've spent a lot of time on criminal. Maybe we can move on to civil accountability for a few minutes and talking about that pathway. Are there civil legal pathways in Canada, such as lawsuits for torture or for wrongful death, that Tamil and Tutsi survivors, for example, could pursue against alleged perpetrators?
Okay, yes.
The big shift.
Yes. Well, so I hate being the bearer of bad news, and I don't want to be negative. I always try to find the opportunities and to make sure that I can give a message of hopefulness, but also manage expectations. And I think managing expectations is really important here. So unfortunately, what I will say to that is that, as I mentioned earlier, the State Immunity Act in Canada is the biggest barrier to civil claims against state violence or state abuses, such as torture, or other types of crimes that might be committed by, the state that leads to wrongful death or harm or, other types of abuses. Essentially, this legislation just makes it impossible for a foreign government or an agent of a foreign government to be sued in Canada for committing these types of abuses. I used to work at the Canadian Centre for International Justice, as you mentioned in the intro, and with the CCIJ, this organization, we were involved in a famous case that went to the Supreme Court of Canada. It was known as the Kazemi case. This was the case of Zahra Kazemi, who was an Iranian-Canadian photojournalist who was arbitrarily arrested in Iran, detained, and was killed in custody. And we brought this case, CCIJ brought this case, and what the Supreme Court ultimately said was that the State Immunity Act has specific exceptions where foreign governments can be sued in Canada. And unfortunately, human rights abuses, torture, violations of international crimes, those are not any of the exceptions that are in the statute. And the Supreme Court of Canada, the judicial branch of the Canadian government, can't read in exceptions that do not exist in the legislation. So it's up to Parliament to legislate these exceptions. So if we want to be able to carve out an exception for human rights abuses, which should never be allowed, then Parliament needs to make that exception very explicitly clear in the legislation, and they have to amend it. So right now, until Parliament explicitly amends this statute, this is an avenue that is not available to many survivors when it comes to state violence, which is the predominant situation or scenario for many cases, including the communities that you mentioned. For example, Tamil victims.
So how could the State Immunity Act potentially be amended or changed? Can diaspora communities do anything to change the law?
Yeah, so this goes back to our conversation about political will, right? And so the same thing applies to this kind of pathway. I think that if enough communities bring this issue to their members of parliament, and ideally, if the various different communities that all would benefit from this type of exception, if they can work together and build some form of coordination and solidarity amongst each other, because there's a lot more power in numbers, I think that they can make it clear to the government that this is a priority, and perhaps we can gain more traction and see if there's a possibility for an amendment to the statute. What I will say is that, the Canadian Centre for International Justice worked for many, many, many years to try to get an amendment, including with politicians, members of parliament, even a minister of justice at the time who was very supportive. But ultimately, it didn't happen because they weren't able to get enough political will, and they weren't able to get agreement in the highest levels where they needed this agreement to happen. So it's a challenge, but I do think that consistent and persistent lobbying of the government and engaging with different people within government, different positions. There's a certain element of luck involved as well. If there are the right types of people that are in decision-making power and decision-making positions, then maybe, there is a possibility to find allies and people that are willing to push this. But there needs to be, there's going to be let's say, a lot of political capital that needs to be spent to make this happen. So we need, again, principled politicians, principled members of parliament, parliamentarians who see this as being incredibly important and who are actually willing to put their political capital on the line and to push and get this to happen. So I think there's room, and this is something that I've been trying to do for a very long time, both when I was at CCIJ and since then. So if there's interest in maybe thinking through a little bit more about how to make this happen, this is certainly something where we can have further conversations about to see, what the opportunities might be with the current government now that there has been a change in government. And this is the other piece that's really difficult, right? When you're dealing with the political element, you're dealing with a very sometimes quick rotation of people in and out of certain positions. Even just the prime minister's cabinet. One day you're dealing and interfacing with one individual who's the minister of a certain position, and then a few weeks later, it's somebody else. So it makes it really, really difficult to also build the type of trust, the type of relationship, to be able to actually get that alliance built and to get that momentum to actually get this done. And that's been a really big barrier as well.
Yeah, totally. That's been our experience as well, and we're still a relatively new organization, but that's something definitely that we've seen happen. And like, but at the same time, I'm glad that there's Northern Justice Watch, there's these other organizations, the Alliance, others that are recognizing if we bring our communities together, we can be much stronger to, and kind of pick up each other's when we're feeling tired or worn out or unable to always advocate or feel like we're in a silo sometimes, and just that we can share each other's burden and move together, kind of. And I think that there's real possibilities when we bring more together this way. So I think I'm sure we would love to follow up on some of those ideas and see where it could go. You mentioned that civil litigation has been used to hold corporations accountable. How can we hold corporations accountable if their supply chains or their business ties are contributing to atrocity crimes abroad? What does that look like here?
Yeah, no, that's a very good question. And I think right off the bat, what I will say is that it's a lot harder to get accountability for supply chain abuses because the civil system that we have here, the torts law that we have for personal injury in Canada, depends on some legal technical tests, which involve proving a duty of care, showing proximity, showing foreseeability. There's elements that really require there to be closeness. And so when you get far down a supply chain of a company, proving those elements become more and more difficult. It doesn't mean that it's not possible. It's just a much more complicated type of case. However, if a Canadian corporation itself is involved in abuses or complicit in human rights abuses that happen abroad, then this is something that can be adjudicated in Canada. And perhaps the best way is for me to give you a very concrete example of the case that I mentioned earlier that I worked on, which is the Nevson case. This case was Araya versus Nevson, and it is the leading case in Canada for these types of corporate human rights violation claims. And so just so that everyone understands the facts of the case, I'll just give a very brief overview. A Canadian mining company, so Nevson Resources, a Canadian mining company, decided to enter into a joint venture with the Eritrean dictatorship to build a gold mine in Eritrea. And in this venture, they relied on labor that was supplied to them by the Eritrean government. And the labor was in the form of people who were conscripts. So in Eritrea, there's a system of forced, mandatory, indefinite conscription. Between certain ages, people need to do their conscription, but it is forced. And it tends to be indefinite, which means that there's really no end in sight. And so this is ultimately a form of forced servitude, right? It's forced enslavement. And so these were the types of people who were supplied to the company to build the gold mine, and they were doing this work under threat and duress. And so these individuals, they didn't earn a living wage when they were doing this work. They were housed in very terrible conditions. They weren't fed properly. And many of them tried to escape the situation because of how harmful the conditions were. And a lot of them ended up leaving in very dangerous circumstances to get out of this forced labor situation. And they ended up making their way across, North Africa, through the Mediterranean, into Europe, into different countries. And so 2 law firms here in Canada, including one with whom I work with, represented these Eritrean individuals who had since fled and left. We represented them in a lawsuit against the Canadian company because it was headquartered here in Canada in British Columbia for the company's involvement and complicity in the forced labor and in the slavery, which are crimes against humanity, right? And so this case went all the way to the Supreme Court of Canada, and there was a ruling at the highest court in Canada that corporations can be sued for breaching international law. So if a corporation is involved in a breach of international law, and this includes crimes against humanity or other types of customary international law, then victims can seek remedy against them in Canadian courts. And this was the first time that we actually saw such an explicit pronouncement of this. And it basically opened the door to corporate accountability cases, making it possible for victims to actually seek redress for harms in the country that these corporations are incorporated in and that they have their operations in or their decision-making seat in. And so the case that I just mentioned, the Nevson case, ultimately it was settled out of court. So we didn't really get to see the case fully play out in the Canadian court system. But with that Supreme Court decision, we did get a really important development in the law that makes these cases possible. And so when the next case comes forward, using this as a precedent, we'll get a better sense of exactly how these cases are dealt with in Canadian law. It's still a fairly novel area in Canadian law, and it's not necessarily the easiest case. Just the Nevson case, I'll say, I think was about 7 years in litigation just on preliminary motions to try to make sure that the case stayed in Canada. So that's, 6 to 7 years of time, money, resources. Again, all of the issues that I mentioned when it comes to cross national or cross-border criminal investigations, those same things apply to cross-border civil investigations. It was very complicated and it took a very long time. And all of that time, all that was able to come out of it in the court system was simply a pronouncement that these cases are possible in Canada. It would have taken probably another several years to actually go to trial and to be able to get the case adjudicated in court. That didn't happen in this case, and so we'll have to wait and see how Canada treats these cases. But it's an avenue that's possible, and it's certainly one that communities should be aware of, and to think through if there are facts in their own situation that involve a Canadian company that is complicit or that is involved in these types of abuses, then it's certainly worth exploring that and seeing what might be possible.
So one follow-up question just about when a Canadian company is complicit, or so for example, there's some Canadian technology that was used in drones that Turkey sold and we had a ban on selling drones to Turkey for a short period of time because of what was happening in Armenia. Those same drones were used in Tigray. They were sold to Ethiopia. They were used in Tigray, and they're continuing to be used throughout Ethiopia in other situations that are terrible. And I'm wondering, in that case, I mean, that seemed like a political response, essentially, to what was happening. When it's Canadian technology that's used in that kind of, is that too what you were talking about with supply chains, where it's not necessarily something that can be tied back directly then to be held accountable here legally for?
I think it certainly depends on all of the facts of a situation like this. What immediately comes to mind for me here is that technology can be developed and it can have a plurality of uses, right? It can be dual use. It can be for military purposes. It can be for civilian purposes. So when you have something like technology, it can apply to a variety of different contexts. So the question here is there information available to actually demonstrate or show that, let's say, the Canadian company knew that by selling this technology to a particular client, that would be used in this fashion, right? Is it plausible to be able to make that link? Was there an element of foreseeability? Did they not do enough due diligence to understand who their client was, what purposes or uses the client would have had for that technology? And was it incumbent on them to make sure that, so there's all these questions around like the level of knowledge of the company, the level of proximity, the foreseeability, all of those are going to be very important factors that are really going to be on a case-by-case basis. But what I will say is that I'm certainly happy to have a private follow-up conversation on this, if it would be helpful to really think through that a little bit more.
Yeah. Okay, very cool. Thank you. That's great. Okay, so my last question for my section. I know there's a couple that have come in from the audience, and this would be your last moment. If you have other questions from the audience and you would like to submit them, please do in the next couple of minutes, because after this, we're going to move into that. But in your presentation, we talked about political accountability that we just also kind of referenced. You know, uh, Ethiopia and Eritrea, again, had allies like the UAE. They supplied weapons to the conflict. Uh, is there a legal way for Canada to hold third-party states accountable if they're enabled atrocities wherever they occur?
Okay. Okay, so just so I understand correctly, so in the conflict between Eritrea and Ethiopia, let's say the UAE supplied weapons to both countries.
So with the UAE, yeah, the UAE supplied weapons to, well, and I mean, we're seeing it also in Sudan happening
Yeah.
right now.
Yeah.
But like with Ethiopia and Eritrea, they had weapons that were supplied to them that were used in the conflict in Tigray.
Okay.
And I'm wondering about, and
Yeah.
I mean, even in corporations again that are, could they be held accountable if it's in a third party state?
Yeah. Okay.
Yeah.
So okay, so I guess since we're focusing on domestic accountability, I won't discuss some of the like international mechanisms that may be
Right.
available to Canada for something like this. For example, you know, if the UAE supplied weapons and the supply of those weapons was against an international treaty that they're a party to, there could be recourses under international law, like we discussed earlier, an International Court of Justice case, a treaty-based case. That would be like an international accountability mechanism. So I won't talk about that. If we're looking really just and focusing just on domestic accountability mechanisms, well, the first thing we know is that legal accountability mechanisms are not available, right? Because we have the State Immunity Act. So we know that foreign governments are not able to be held accountable under civil law because of the State Immunity Act. They could potentially be held accountable under criminal law, but that gets a little bit more complicated. So maybe what I'll focus on here and what could be the most interesting here is the political accountability category that we discussed earlier. So in a scenario like this, if the UN Security Council has imposed sanctions on the UAE for breaching international peace and security, then Canada would have an automatic obligation to impose sanctions on the country as well. So that's one way in which if there is a UN Security Council sanction, there's a UN mandated sanction, this would be something that Canada would automatically have to do. It doesn't even need political will or political discretion. It would be part of our legal system where they would have to implement any type of UN sanction that has been imposed. This now involves, a whole host of other political questions around the United Nations and what's possible, what's not possible, what would potentially happen. But that's one political way that Canada can get involved. Now, Canada also has sanctions regimes under a legislation called the Special Economic Measures Act, which it can also use at its own discretion if it believes that a country is engaging in conduct that is either against Canadian interest, Canadian national interest, or against international peace and security. And a really concrete example of Canada doing something like this is what we've seen with Russia, right? So with the war in Ukraine and with Russia's conduct in Ukraine, we have seen exponential number of sanctions over the last 2-3 years on Russia, on Russian entities, on Russian individuals. So this is something that Canada could use as a political tool. And so if there is political will, right, if there is political will in Canada to impose these types of sanctions, then the Minister of Foreign Affairs would be the one that has the discretionary power to determine whether or not to do it. And this would be also a pathway. And then there's also another sanctions regime that we have in Canada, which is the targeted human rights sanctions that I mentioned earlier as well. And this is really a system that is meant to target individuals and entity for very specific human rights abuses or forms of corruption. And this is something that Canada has also used. So if the supply of weapons by the UAE to this conflict, if those weapons can be linked to specific incidents of extrajudicial killings, torture, sexual violence, arbitrary arrests, or other comparable types of abuses, then individuals or government entities within the UAE can also be sanctioned using this regime. And so it gets a little bit technical, right? Because we've got three different kind of legislations, three different types of sanctions. They're meant to all work in some level of synergy, and they're meant to all have very distinct targets and objectives. And so they're meant to work in a cohesive way. But one really important thing that I would like to mention about sanctions that I think is important to keep in mind when thinking of sanctions as a tool is that sanctions by design, at least the way the Canadian government has conceptualized the sanctions regimes here, they are not meant to be permanent. They're not meant to be accountability in the sense that they're punishment for something. They're really meant to be a tool that allows the Canadian government to elicit some type of behavioral change in a country, in a government, in the leadership of a government. And so in this case, they would really be using this as a way to encourage, let's say, from your example, the UAE to stop sending weapons or not to send weapons. So they would really be using this as a responsive tool in an ongoing situation rather than something that's after the fact, generally speaking. Because the sanctions regime, like sanctions themselves, they're kind of like a carrot and a stick, right? They have the goal of getting a country to stop engaging in conduct that is against Canadian values or that is problematic to Canadian interests or international peace and security. And the moment that a country then complies and stops engaging in that conduct, then technically those sanctions will then be removed. So they're not meant to be there indefinitely or permanently. So they should really be thought of as more of a responsive tool rather than a accountability process in its truest form, if that makes sense.
That does make, oh, sorry, I was on mute. That does make sense. A question around sanctions, like with, off the top of your head again, but can you think of a case where sanctions were lifted because they're not a permanent form, but then reimposed? I'm thinking, so in particular, like the case of Eritrea, Canada had sanctions, arms embargo, travel bans, asset freezes against Eritrea. And because there was this perception that there was diplomatic momentum in the Horn of Africa, there was a peace agreement between Eritrea and Ethiopia, which actually became the basis of the genocide in Tigray. So there was a misreading of the situation, I think, that happened. And Canada, because the UN Security Council lifted sanctions, Canada followed suit and did that as well in June of 2020. And then the conflicts that Eritrea and Ethiopia, and what they did to Tigrayans started November 2020. So it seems like it was a mistake, perhaps, to have lifted those sanctions. And, are there cases where there's admission of something like that, or where sanctions are reimposed that you can think of off the top of your head? I'm sorry to put you on the spot with that, but, because it's something that we've talked about as being an error that should be corrected based on what's happening in Eritrea domestically and how their influence internationally.
Yeah, no, it's a really good question. So in theory, because again, this is a responsive tool, it's a political tool, it requires political discretion at the ministry level, and it's meant to be an ongoing monitoring of what's happening in real time and used as a way to try to, again, elicit some type of change. In theory, the Canadian government can impose sanctions. They can remove sanctions because they feel that the government has complied with whatever it is that were the objectives or the goals in the first place. They can preemptively remove sanctions in a show of good faith if they think that that's going to encourage potentially some change of behavior. And then it certainly doesn't stop them from then reinstating sanctions down the line if a country engages in the conduct again, if there's a regression in a situation, if there's a backtracking. So I think when we think of this as a responsive tool, it's not that it happens one time and that's done. And certainly within the sanctions regime, what we've seen is that there's like sanctions imposed on a situation, and then there are individual entities and people that are targeted within those regimes, and those lists are constantly being updated as well. So, if we have, let's say, sanctions on Russia, then there will be like an added list of the individual people and the entities, the government departments, even corporations, private parties, all of these people that are going to be specifically put on a list to be sanctioned. And that list is constantly changing. People can petition to get delisted if they think that those sanctions were imposed on them illegitimately. So it is there's a flow to this. And so there is a possibility. What I will say is that there have been examples of Canada removing sanctions. You're correct about that. I think it's happened in not that many countries. Eritrea is one of them. I believe it also happened in Côte d'Ivoire. They had imposed sanctions. I think it was related to the civil war that went on, and then they removed those sanctions in Liberia, in Mali, in Rwanda. I think in the former Yugoslavia, and if I'm correct, I believe in Sierra Leone as well. So there are examples where Canada had imposed sanctions and then they removed them. And certainly, if the sanctions are imposed through the UN regime, if the UN Security Council removes sanctions, then Canada can also then remove sanctions as well. Mm-hmm. So it's going to be something that is a constantly evolving situation. So I think in a case like you mentioned, where there may have been a miscalculation or a misunderstanding or even just incorrect information, a mistake, it certainly doesn't bar communities from making sure that the correct information is brought to the attention of the minister, and from lobbying or petitioning or trying to get information to the relevant sanctions teams to ask them to actually impose sanctions once again. So that's certainly an avenue that is open.
Yeah. Amanda, I could keep asking questions and talking to you all day. Thank you for all this. It's so helpful. I know we have a couple of questions. Let me find them here just one second that have come in through the chat. Okay, so the first one I have here, I think this is really interesting. Okay, so information and record keeping. Information and record keeping are different from people and cultures. Where I come from, record keeping is done through songs. How can groups that have different forms of record keeping put forward cases of abuse? Canada's court systems use official evidence, usually in the form of writings, and often disregard information such as cultural songs that it deems as not usable. Thoughts on that?
That's a really good question. And I think it's a really important question that highlights the fact that, information is processed and disseminated and preserved in so many different ways across different cultures. I also come from a culture that, incorporates a lot of oral and musical, memory. I don't have a satisfying answer because, unfortunately, when it comes to something like a criminal justice process in a country like Canada, there's a system within which we are operating in, and the system exists in a certain way because there are also competing issues that need to be balanced, right? As I mentioned earlier, there needs to be a level of specificity, a level of preciseness, and a certain standard by which evidence reaches a certain threshold to be able to prove that somebody has committed an act. And the reason the threshold is so high, and the reason that there's such a high bar, is that as a society, we understand that, imprisoning someone for their life is a really big price to pay, right? It's the remedy that is sought, the fact that someone could be prosecuted and ultimately imprisoned, we're depriving someone of their liberty, which is a really, really big thing. And so we don't want to be depriving someone of their liberty if they did not do the crime. So there's a competing interest here, both in terms of the rights and the human rights of the victims but also the human rights of alleged perpetrators or suspects who may or may not be the actual suspect. And the criminal justice process is meant to be a form of seeking truth, and being able to prove beyond a reasonable doubt that this individual that is standing in this courtroom is the person who did this, and we have sufficient proof to feel comfortable to put them away and to essentially deprive them of a very fundamental right. That's the way that our criminal justice system is conceived. And so based on that conception here in Canada, and I would like to make note that this is also a colonial system, right? This is a common law colonial system that we have as a result of, you know, the British coming to Canada, and bringing a system with them. If we were to look at Indigenous justice systems, there might be very different ways that these types of cases could be adjudicated or pursued. And different Indigenous communities, different groups here in Canada have different legal systems and different ways that they would address this. So we're really looking at a very narrow and specific legal framework that we have in Canada. And in order to be able to avail ourselves of this, we have to do it based on the criteria and the system that is available here. But that is for criminal justice, and that's for legal accountability. That doesn't mean that there aren't other ways of seeking justice that are not necessarily legal based, right? Justice, the concept of justice can be so much broader and so much bigger. And it can be a lot more victim-centered, because our criminal justice system, the common law system that we have, is actually not centered on the victim. The victim doesn't have an official role to play in this system. And when we prosecute, it's not the victim bringing a case against an individual, it's the state, right? The Crown brings a case against a perpetrator because we have determined as a society that we believe that this type of conduct is harmful, and it is for all of society that these cases are being brought. It's not being brought necessarily for the victim. And so it often is not a very satisfying avenue for victims, right? So I think we need to think of justice a lot more broadly. And I think that's where art, that's where music, that's where culture, that's where stories, that's where community, that's where we can actually do healing through a lot of broader endeavors beyond just the legal system. So I know that that's not the most satisfying answer, but really that's the best I can do.
Yeah, no, that's helpful. It's great. There's a lot to think about there. But you know, but coming back to even the idea of like a song, so could songs, if there's a popular song that expresses that something happened, and you know, there was a certain perpetrator, and it's that sort of knowledge that's passed down somehow or spread, could that be included in a structural investigation or context to be understood as like common, or would that just, is it totally, I mean, or do you have to prove that like this is the way this community speaks or shares its history essentially, and you know, would it just be totally not helpful to a case?
Yeah, no, it's a good question. So I have a couple thoughts. So first is that lead information can be a lot of different things, right? To just say, hey, I think something happened and it needs to be looked into, it needs to be investigated. And let's say there's a song that helps me identify where something may have happened because that was incorporated in the song, right, or who did it or who was victimized by it. These are kind of these broader elements that certainly can give rise to looking further, right? And that already is a big thing, is to say, oh, you know what, something may have happened, and maybe we need to actually start digging deeper and start asking questions and maybe start an investigation. Absolutely, right? However, a song, the way that I can kind of speak to it in, let's say, legal technical terms, is a concept that we have, which is hearsay, right? And I don't know how much people know about this, but hearsay is generally not admissible in court when it's not when the information that you have is not firsthand information. And in a lot of communities, again, my community included, you know, there's information that people are like, well, I know because like it's common knowledge, like everyone
Mhm.
knows. You know, when I interview certain people, when I'm doing, you know, victim interviews or witness interviews, I actually get this response quite often, which is like, oh, so and so did it. And I'm like, well, how do you know it was so and so? It's like, oh, everyone knows, it's common knowledge, you know? And so as an investigator, I have to like keep peeling back the layers and trying to get a sense of, but how do you know? Like how did you get this information? Did you see it yourself? Did you hear it yourself? Did you experience it yourself? Because the system that we have in place is really, it privileges that firsthand information and not so much the more common general information. And so unless the person who wrote the song, who is the source of the information, is the person that we have with us, just a song that may have been shared, that may have been spread, where different people have access and maybe has also been altered and changed because everyone has their own spin on a song, their own interpretation, that on its own would be something like hearsay, which is not necessarily at that level, at that threshold that we need to be able to use it as evidence. But it doesn't mean, again, it's not valuable. It can be very valuable, but in different ways, in helping build an investigation, in helping shape the contours of an investigation, but certainly not as evidence.
It's so interesting. Thanks for the question. I really appreciated
Yeah,
that
that's
dive
a
into that. That
very,
was very, because it is common. It is very common to have in many communities for people to just say, well, we know this is what happened. But yeah, anyway.
well,
So
and
yeah.
it's also, you know, in a lot of oral traditions, you know, you don't have people writing things down
Yeah.
on paper, right?
Yeah.
And so when we have documents here and we say, well, you know, so for example, you know, something happened to me and I wrote it down in my journal and I wrote down the date and I wrote down this happened to me, that can be used as evidence because it's a
Mhm.
document that someone in the moment wrote down exactly what happened, and it's a form that we look at and we say, okay, this can be used as evidence, right?
Yeah.
But we don't have that equivalent in cultures where it's like, well, I didn't go and write in my journal, but I composed a song and I sang a song and I shared the song, right?
Yeah. Yeah.
And so it does show the limitations, you know, of the system that we have, and it does make us ask these questions around, you know, in a globalized environment where so many conflicts are happening in so many places that don't necessarily base themselves on a civil law or a common law system, you know, how do we have a more pluralistic view of legal traditions, and how do we incorporate the way that these things are done in other cultures and communities into the systems that we have? And one thing about universal jurisdiction that is important to keep in mind is that we're asking a Canadian government to adjudicate on something that happened outside of Canada. And that
Mhm.
on its own is kind of it's kind of a rarity, right? Normally, you would have the domestic legal system where the crime occurred responsible for adjudicating that crime. And in those situations, you probably do have a much better and bigger appreciation for the cultural aspects of what happened. But if you don't have the opportunity or the possibility to get legal recourse in the country where it happened because of a variety of issues, including governance gaps or not having a legal system that it has the political will or the ability to do this, when you're asking a different legal system in a different country, in a different culture to do this, you're going to see a lot of points of tension. Because that's not really where justice should be sought. It's a last resort because no other place that is probably more appropriate is available. And so that is also a tension that I think is important to keep in mind.
Mhm. Yeah. Okay, we have one last question that's come in, and let me just read it out here. Okay, are people who are arrested through universal jurisdiction those who have committed these gross violations given the opportunity to appeal, or is this a matter of a case-by-case scenario? I think maybe this person meant are people who are prosecuted, through universal jurisdiction, those who have committed these gross violations given the opportunity to appeal, or is this a matter of case-by-case scenario?
So prosecutions that happen in relation to the Crimes Against Humanity and War Crimes Act are still happening procedurally within the general Canadian criminal framework. And so because of the due process that we have enshrined in the system, then just as a domestic criminal case would be adjudicated, so would an international case, which means that, yes, there are appeals that are available on certain specific grounds. And so it doesn't mean that it's a completely different system. It's the same system, but we're just looking at different bases for charges and for the prosecution.
Okay. I don't see any more. I'm just going to double check that there's nothing else that is, nope, there's nothing on my end. So wow, here we are, 2:05. Thank you, Amanda. Thank you for pouring so much wisdom and clarity into these 2 sessions now. I think you've offered your knowledge so generously, and I think it gives us not just ideas of possible directions to pursue, but there's also a sense that you're walking alongside us in this struggle. So we don't take that for granted. And thank you very much for everything. I would say to everyone listening, please keep an eye out for updates about session 5, which I'm sure is around the corner. I don't think there's, I didn't get a title, so I'm just going to say, so on social media channels, keep an eye, and I'm sure Northern Justice Watch will have that out shortly. Thank you all for being here today. I think, your presence on a Sunday, a summery August Sunday, shows that, your depth of commitment to justice and accountability. So thank you for the questions also. And I think what we've heard today, is it feels clear. We know that atrocity crimes don't end when the guns fall silent. They follow survivors into exile, into our classrooms, into our neighborhoods, and Canada cannot look away. Justice isn't abstract. It really lives in the stories that we carry and the evidence we preserve and the pressure we place on our systems here to respond. And Canada has laws, and Canada has obligations, and Canada has us. Survivors, allies, advocates, and we refuse to be silent. So I think as we close, I hope that we commit to taking what we've learned and to turn it into action. Let us ask new and harder questions of our government and support one another and keep raising our voices and share evidence and support survivors and push for accountability. And we know that accountability will really only come if communities and collectives like ours insist on it. So on behalf of Northern Justice Watch, if I can say that, and our partners, thank you for engaging and learning and standing together today. And let's all keep pushing forward until the best justice that we can provide is actually realized through survivors. I believe there are survey questions from Northern Justice Watch that are going to come up. The team is going to share on the screen. There's a series of them. It would be helpful to receive any feedback that you have on how helpful these 4 sessions have been so far. I think there's a series of 12, so they want to incorporate your thoughts on how it's going so far into whatever it is that's being planned next. And they want to be bringing helpful programming like this to community. So if you could take a few minutes to respond to some of that as it comes up on the screen, that would be great. I believe you can drop your answers in the chat. Here's the first one. What does justice mean to you in one word? And I understand there's a number of them. I think there's 7 or 8 questions that are going to come up. And that's the same one. So if you wouldn't mind hanging on for a second, and you can answer some of these in the chat. You can also email or message Northern Justice Watch, I'm sure, and you'd be able to express your feedback and your thoughts that way. I thank you all very much for your time today, and we'll see you at session 5.